Secretary General of the Office of the Chief Justice. Please welcome to our meeting. It is now the opportunity for you to share with the Portfolio Committee and the honorable members.
Oh, I can't hear the chairperson. I can't hear the chairperson.
You can't hear the chairperson. I can hear you. I can hear you.
The other one, this one. Yeah, just
Can you hear me now? Can you hear me now?
I can hear you, chairperson. Thank you.
Okay. You don't seem enthusiastic. Can you hear me?
I can hear you, chairperson. I can hear you loud and clear.
Thank you, SG. I want to invite you to take the podium and make your presentation. Welcome.
Thank you, chairperson and members of the Portfolio Committee. Myself and the team will present the Annual Performance Plan 2022-2023 financial year as already tabled. And the head of planning and strategy and reporting, Mr. Malawi, will lead the presentation, after which we shall take the questions. Thank you very much. Mr. Malawi, over to you.
Thank you, SG. Good morning, Acting Chairperson, Honorable Acting Chairperson, and all members of the Portfolio Committee. Thank you for inviting us to share with the committee the OCJ 2022-23 Annual Performance Plan. Honorable Acting Chair, our presentation of the day is structured as follows. It's got three parts. Part A, the overview, which has the following focus areas: the purpose of the presentation, the introduction, and the consultation that was undertaken by the Office of the Chief Justice in developing this APP. And Part B will focus on the situation analysis with a focus area on environmental scan that was conducted. And Part C, which focus on measuring our performance. It will basically focus on the program performance information. As the chair and the honorable members of the committee may be aware that the OCJ has three programs. The first one is administration. The second one, program 2, is superior court services, and program 3 is judicial education and support. So we'll be talking to the deliverables, the outcomes, and the indicators and targets in respect to all these three programs. And the other part that we'll be talking about, we'll be presenting, will be the financial information and the updated risks, and that will be the end of our presentation. Honorable Chair has already indicated the purpose of this session is to present to the Portfolio Committee the OCJ Annual Performance Plan for the 2022-23 financial year. And in terms of introduction, Chair, the APP for the 2022-23 financial year is the third APP towards achieving the outcome and realizing the impact as outlined in the OCJ 2020-2025 strategic plan. When developing this APP, the following instruments were taken into consideration: the DPME revised framework for strategic plans and annual performance plans, the National Development Plan, which is the blueprint of government, and the revised medium-term strategic framework, as well as the overall priorities of the judiciary. In developing this plan, Chairperson, the following stakeholders were consulted in the process: the Department of Planning, Monitoring and Evaluation, Department of Women, Youth and Persons with Disabilities, National Treasury, the Auditor General of South Africa, the Audit and Risk Committee of the OCJ Executive Committee, the OCJ Operations Committee, as well as the Ministry. Moving to Part B of our presentation, Chairperson, one of the key requirements or priorities of planning, Chairperson, requires that when we plan, we also take into consideration or into cognizance the environment in which we operate in. And to give effect to that, the OCJ has identified both the internal and external factors that has a potential to affect the successful implementation of its plans. And in terms of the external environment, the following factors were identified. the impact of the current status of the economy on access to justice, social factors and their influence on the justice system and court administration, technology and its role in improving access to justice, the legal factors impacting on judicial system and the administration of superior courts. In terms of internal factors or internal environment, the following were considered: the capacity of the OCJ, capping opportunities for fraud and corruption, the health and wellness program, the ICT as a strategic business partner. The financial resources at our disposal was also one of the factors that were considered, business continuity management, and the status of institutions regarding the compliance with BBBE Act, and lastly, the status of the institutions regarding women, youth, and people with disabilities. Honorable Acting Chair, I'm moving now to Part C, which basically focus on the performance information with the direct focus. The first focus will be on administration, Program 1, which is administration. Program 1 facilitated through the following outcome: effective and efficient administrative support. And in order to realize this particular outcome, Chairperson, we've got a number of outputs which are key to achieving this particular outcome. The first one the first output is clean audit outcome for the Office of the Chief Justice, and the output indicator thereof is audit outcome for the OCJ. And over the MTF, the first year of the MTF, our plan is to ensure that clean audit outcome for the OCJ is achieved for the 2021-22 financial year. The same applies to the 2023-24 financial year. Our aim is to ensure that we have a clean audit outcome for the 2022-23 financial year, and the same applies to the last year of our MTF, which is the 2024-25, to a clean audit outcome for the 2023-24 financial year. The next output in realizing this the outcome is tenders awarded to suppliers with level 4 and above BBBE status, and the output indicator is percentage of tenders awarded to suppliers with level 4 and above BBBE status. And our aim is to ensure that over the MTF, 80% of all tenders are awarded to suppliers with level 4 and above BBBE status. The next one is output indicators. The next output indicator is financial disclosure submitted. My apologies, financial disclosure submitted, and the output indicator for that one is percentage of designated employees, which includes both SMS and other categories as prescribed by DPSA, who submitted financial disclosures within the time frame. And our target over the MTF is to ensure that 100% of SMS, including all this category of other employees, submit their financial disclosures within the required time frame. The next output in realizing the outcome on effective and efficient administrative support is funded vacant posts reduced, and the output indicator is percentage of vacant posts on the funded establishment. And over the MTF, Chairperson, our aim is to ensure that we keep our vacancy rate at 10% or lower. Other output is empowered youth. The OCJ continue to ensure that it prioritizes the empowerment of youth. And the output indicator for this particular output is percentage of staff in the department comprised of youth. And our aim is to ensure that over the MTF, we have 30% of our staff comprising of youth. The next output, Chairperson, is women representation at senior management services, which is SMS level. And the output indicator is percentage of women representation in senior management. And over the MTF, our target is to ensure that 50% of women are represented at least at SMS level. So this means that over the 2022-23, the target will be 50% in the 2023-24, 50% as well in the 2024-25 financial year. The other output is people with disabilities representation, and the output indicator is percentage of people with disabilities representation in the department. And the target over the MTF is to ensure that we have 2% representation of people with disabilities within the department. Continuing with the outcome on effective and efficient administrative support, Chairperson, the other output is court online system implemented at service centers. And the output indicator for that particular output is number of service centers with court online system rolled out. And in the first year of our MTF, which is the 2022-23, our plan is to ensure that the court online system is rolled out in 5 service centers. And then in the 2023-24 financial year, we will also roll out to additional 5. And then in the 2024-25, we'll ensure that we roll it out to 11 service centers. Other output is employee health and wellness programs. And the output indicator for that output is number of employee health and wellness programs implemented within the OCJ. And our plan is to ensure that over the MTF, we roll out every year 9 health and wellness programs within the OCJ. Our output is fraud cases investigated within prescribed time frame. And the output indicator for that one is percentage of fraud of reported fraud cases investigated within 60 working days. And we'll ensure over the MTF that at least 75% of fraud cases are investigated within 60 working days. Next one is fraud prevention and anti-corruption awareness sessions, and the output indicator thereof is the number of fraud prevention and anti-corruption awareness sessions conducted. And then our plan is to ensure that over the MTF, for each year of the MTF, we'll conduct 25 fraud and anti-corruption awareness sessions across all the superior courts. Chairperson, slide 13, with your permission, I would like to skip because it's just a breakdown of the annual targets into quarterly deliverables. The same applies to slide 14. So with your permission, Chairperson, allow me, because I've already indicated the annual targets, for those particular indicators. Moving to slide 15 now, Chairperson. As much as, Chairperson, we recognize the strides that has been made by government in reducing the spread of COVID-19, we also acknowledge that as a country, we are not yet out of the woods. And as a result, management has resolved to retain the following set of indicators relating to COVID-19 as a measure to manage the risk pertaining to this pandemic. We have about 5 indicators that will be responding to COVID-19. The first one is number of COVID-19 OHS inspections conducted within the OCJ. And the annual target is 4, meaning that every quarter we will be conducting 1 inspection. And the second one is number of COVID-19 awareness programs implemented within the OCJ. And the annual target as well is 4. And then our plan is to ensure that every quarter we conduct 1 awareness program within the OCJ. The third indicator in relation to COVID-19 is number of COVID-19 related trainings conducted for safety officers. And the annual target for the 2022-23 remains 4, meaning that we'll also conduct 1 training for safety officers across the OCJ per quarter. And the other one is number of COVID-19 compliance reports produced, and the target is 4 as well. And then our intention is to produce 1 COVID-19 compliance report every quarter. And the last one, Chairperson, is number of COVID-19 pandemic risk mitigation reports produced. We're also intending to produce 4 reports, meaning that there will be a report in relation to COVID-19 pandemic risk every quarter. Moving now to program 2, which is our core business, Superior Court Services. The outcome for this particular program is improved court efficiency, and it also has a number of outputs. And the first output is default judgments finalized within 14 days. And the output indicator for this particular output is percentage of default judgments finalized by registrars within 14 days from date of receipt of application. And during the 2023-23 financial year, the target that has been said by the OCJ is to ensure that 74% of default judgments are finalized by registrars within 14 days from date of receipt. And then in the 2023-24 financial year will increase by 2%, it will be 76%. And 24-25 financial year will also increase by additional 2%, meaning that it will be 78%, the target will be 78%. The next output in realizing the outcome on improved court efficiency is bills of cost text within 60 days, and the output indicator for that particular output is percentage of taxations of legal bills of cost finalized within 60 days from date of set down. And the target in the 2022-23 financial year is 80%, and then it will be incremental by 5% in the 2023-24, it will increase to 85%, and 24-25 financial year, it will increase to 90%. The next output under program 2 is warrant of release delivered within 1 day, and the output indicator is percentage of warrant of release delivered within 1 day of the release issued, and the target over the MTF will be 100% for each year of the MTF. The next one is monitoring reports on law reporting project, and the output indicator is number of monitoring reports on law reporting project. Our plan is to ensure that we produce 4 reports over the MTF. So every year, every quarter will be having a report to cover for all the quarters. The next output is judicial case flow management performance reports, and the output indicator is number of judicial case flow management reports produced. And over the MTF, we'll ensure that every year of the MTF will produce 4 reports. Next output is report on enhancement of court order integrity, and the output indicator is number of reports on enhancement of court order integrity produced. The plan for the 2022-23 is to produce 4 reports. Same applies to the 23-24 financial year as well as the 24-25 financial year. Chairperson, once again, the next slide, which is slide 19, is a breakdown of the annual target into quarterly targets. With our permission, I would also like to skip this one and move straight to program 3, which is our last program, which is judicial education and support. And the outcome for this particular program is enhanced judicial performance, and is also driven by a number of outputs. The first output is judicial education courses, and the output indicator is number of judicial education courses conducted. And the plan in the 2022-23 financial year is to conduct 110 judicial education courses, and in the 2023-24 financial year is to conduct 115, and 24-25 to increase it to 120. The next output in realizing this outcome, the outcome on enhanced judicial performance, is monographs on judicial education, and the output indicator for that one is number of research monographs on judicial education produced, and our plan is to produce 2 monographs each year of the MTF. The next one is monographs reports on the management of monitoring reports, on the monitoring reports on the management of litigation. And the output indicator is number of monitoring reports on the management of litigation produced. And our intention is to produce 5 reports on each year of the MTF. Next output indicator, the next output is reports on judicial appointments and complaints, and the output indicator is number of reports on judicial appointments and judicial complaints produced. And the intention is to produce 3 reports in the 2022-23, which is basically the 2 reports that are aligned to the sitting of the JSC as well as the annual report. And the same applies to the 2023-24, it will be 3 reports, and 24-25, 3 reports as well. And the last one under this particular program is reports on disclosures for judges' registrable interest. And the output indicator is number of reports on the status of disclosures for judges' registrable interest produced. And the plan is to produce 2 reports on each year of the MTEF. I'm gonna skip the next slide, Chairperson, as it's also a breakdown of the annual targets into quarterly deliverables. And Chairperson, allow me to pause there and hand over to the CFO, who will take the committee through the financial information. Thank you.
Good morning, Acting Chairperson and Honourables. I'm going to take you through the slide dealing with the financial information for the MTEF period. The allocation of the budget for the next 3 years are as follows. In the administration program, Program 1, 255 million rand, growing to 271 million rand over the 3 years. Superior Court Services, 958 million, growing to 960 million in the 3rd year. Then Judicial Education and Support, 52 million, growing to 55 million in the next 3 years. Then in terms of the direct charges, judges' remuneration and gratuities, 1.122 billion in the 1st year, growing to 1.175 billion in the 3rd year. So in essence, the total budget of the OCJ is 2.388 billion in year 1, which then grows to 2.463 billion in year 3. When we break it down in terms of economic classification, the compensation of employees that is reflected on screen includes the salaries of judges as well as the voted funds for salaries of officials. So the total amount is 1.768 billion for both these categories. And then more specifically, the voted salary COE ceiling for the 1st year is 780 million of the 1.768 million. Goods and services grows from 371 million per annum up until 381 million for the last year. Transfers and subsidies, mainly where the judges' gratuities are paid from in the direct charge classification, is growing from 135 million to 142 million in the last year. And then purchase of capital assets, 112 million, moving to 120 million in the 3rd financial year. The main issue that we've been reporting consistently on the budget and the effects of budget cuts on the OCJ still remains on the issue of compensation of employees, but that has been consistently reporting as a problem for the OCJ. So that deals then with the presentation on finance. Thank you, Itumeleng.
Thank you, CFO. Chairperson, I'm going to move straight to the risks. The next slide will focus on the risks that are associated with the outcomes that we are pursuing as the department. It's already indicated our first outcome is effective and efficient administrative support. And there's a number of set of risks that has been identified in relation to that particular outcome. The first risk is possible exposure to fraud and corruption. And how do we intend mitigating that? Chairperson will ensure that there's continuous awareness on policies. We will strengthen internal controls relating to fraudulent court orders. We will also monitor the implementation of fraud prevention and anti-corruption strategy. The next risk identified in relation to this particular outcome is delays to implement the court online system due to external dependencies. And in terms of the mitigation, we intend to reinforce the stakeholder relation to ensure commitment pertaining to this project resourcing. The other risk that has been identified is possible cyber and information security incidents, which basically includes breaches and hacking. And in terms of mitigation, we intend to accelerate the implementation of the information security management programs. We'll also ensure that we conduct network and vulnerability audits and also ensure the establishment of the threat and vulnerability management programs. Moving to the other risk in relation to the first outcome, the other one is inadequate resources to capacitate the OCJ in order to operate in the new normal. And the risk mitigation is we intend to reprioritize the availability of resources to implement the new way of doing business. And we also intend to implement and monitor compliance in relation to COVID-19 regulation. This will include, amongst others, deep cleaning and sanitation of the affected area at the coast and national office after any confirmed cases has been identified or reported. Chairperson, I'm moving to the second outcome, the risk pertaining to the second outcome that we have, which is improved court efficiency, which is mainly linked to our core business, which is superior court services. And the first risk in relation to that particular outcome is inadequate administrative support to ensure court efficiency. And the risk mitigation, we intend to mitigate this particular risk as follows. We'll prioritize the appointment of registrars, and we'll also ensure continuous training of the registrars. And the last outcome, which is enhanced judicial performance, which is linked to program 3, the risk pertaining to that particular outcome is inadequate resources to conduct judicial education. And in terms of mitigation, we will ensure that we continue to implement the visual and e-learning modules for judicial education as a way to mitigate, this particular risk. Chairperson, this brings us to the end of our presentation, and thank you for affording us the opportunity to share with the committee our annual performance plan for the 2022-23 financial year. I thank you, Chairperson.
Thank you, SG. Any final comment? You are muted, SG.
Can you hear me, Chairperson?
Yes, we hear you when you're not muted.
Oh, sorry. I was saying that the presentation for the 2022-23 APP has been given, and we will take questions from the members, including any other comments that we will make relating to the issues that arose in the minister's overview that touches on the OCJ. We are in your hands, Chairperson.
Thank you, SG. Honorable members, I invite you to step on the podium and engage this APP of OCJ. Any points, questions, clarities, and contributions that you have to the office. Honorable Breitenbach, followed by Honorable Wilma, Honorable Werner Horn.
Thank you, Honorable Chairperson, and Dean, good morning to everybody. I'm going to start with my most recent concern. So, looking through the previous 2 years' reports, the issues raised remain the same, which is somewhat of a problem, but I'll get to those. My most recent concern is the oversight visit to the Supreme Court of Appeal, which left, I think, the entire committee feeling deeply concerned, but also quite angry at how that court, which is a very important court in our judicial system, is being treated. So they have a number of infrastructure challenges, and so my question boils down to what is the relationship between the Office of the Chief Justice and the Department of Public Works with regards to infrastructure challenges being faced by the courts. Does the Office of the Chief Justice get involved in these issues and assist the courts? For instance, President Meyer explained to us that the roof of the appeal court has been leaking for some years now, quite badly. So badly that ceilings need to be replaced quite regularly. But nothing is done to fix that. What they do is they just fix the leaks, patch the leaks. So anyone knows that water will find the weakest point and get through. And I see no sense whatsoever in spending large amounts of money patching the roof of a historic building that's constantly being damaged by rain and not repairing the roof properly once and for all. Similarly, the air conditioning has been out of order since 2012. We're in 2022 now. Since 2012, the air conditioning has been either unusable or barely usable. It's not been replaced. It can't be repaired. So they send in a contractor, he repairs it for half a day at great cost, many thousands, hundreds of thousands. It's repaired at great cost, but because the system is not being maintained for 10 years, it's completely useless. And so it breaks down again within hours, and that money is wasted. It's absolutely fruitless and wasteful expenditure. It makes no sense. Spend that money on replacing the aircon system. The Supreme Court of Appeal is designed in such a fashion that none of the courtrooms have outside windows. So if there's no aircon, there's no air. And yet they spend money on patchworking a system that is so dilapidated that it cannot be repaired. They need new aircon. Are we seriously suggesting that our Supreme Court of Appeal must function without air conditioning in 2022? The electricity, they're on a load shedding schedule. The High Court is not on a load shedding schedule, and interestingly enough, neither is the Premier of the province on the load shedding schedule. They have lights 24/7, but the Supreme Court of Appeal gets load shed on a regular basis. It's ridiculous. Does the Office of the Chief Justice get involved in these issues, and do they help to address them? And if so, please tell me how. The Supreme Court of Appeal has no access for wheelchairs. It has one lift. The lift shaft is flooded with water. They're unable to find anybody who can pump it out or fix it. And so the lift just doesn't work. So if anybody needs to access a court in a wheelchair, they just can't. Because there are just too many stairs. It's impossible. That's an unacceptable approach in 2022. Is the Office of the Chief Justice dealing with any of these issues? Then the judiciary court-led administration model. We've been told for some time now about the gains made and the progress made in this process. It would be nice to hear what the progress is to date and what the deadlines are for finalizing this process. Then President Meyer also raised an issue about equipment, particularly IT equipment. The judges get systems and computers forced upon them that cost vast amounts of money, but that they don't need. And that they could manage with much cheaper models, but when they suggest that, then they're told that they have to take those that they get, regardless of the fact that they don't need such expensive models and don't really want them. What is the issue there, and can that be addressed? Then court automation. We have all these problems with the Department of Justice, who clearly cannot get their act together with regards to contract maintenance. And this had a serious knock-on effect to the courts, so much so that the courts just close and cannot dispense with justice at all. So South Africans who get up at 3 o'clock in the morning, catch 3 taxis to get to court, get sent home because the recording equipment isn't working. It's not acceptable. And they don't deserve to be treated in this fashion. And what is it that the Office of the Chief Justice can do in this regard? Are they involved in these negotiations? And if so, how are they involved in? Are they making any progress? And if not, what can we do to facilitate that? We also, to my horror, discover that the system that keeps the automated court records is dilapidated and failing, and in fact doesn't work. Again, that's really in 2022 can't happen. And once again, it just points to a sadly inadequate system within the Department of Justice and perhaps in the Office of the Chief Justice of maintaining electronic databases of very important information. How is this being addressed? How does the Office of the Chief Justice approach this? And if they're having difficulty with it, is there some way that this committee can assist them to address that, what I view is a very important issue? I'm sure that my other colleagues will cover the many, many other issues that must be raised here. But I'll settle for that in the interim. Thank you, Mr. Chair.
Thank you, Honorable Breitenbach. Honorable Velma, Nivo Teruggen.
Thank you, Chairperson. We're just waiting for the interpreter to get the headset on. Good morning to the Office of the Chief Justice and the SG and your team. Thank you for the presentation. I just have two questions. Honorable Breitenbach has covered me in relation to Department of Public Works. I would, however, just like to add to what she has just asked in relation to when was the last engagement between the Office of the Chief Justice and Department of Public Works? When was the last engagement to raise the concerns about the infrastructure, the aircon, and all of these challenges? Secondly, I see that you had a consultation with Department of Women, Youth, and People with Disabilities. I would like to know the outcomes. Well, actually, what was the consultation of, what was the purpose of the consultation, and what were the outcomes? Those are my two questions, Chair. Thank you.
What is the question? Consultation with the Department of
Remote. On.
Disabilities, and what was the outcome of the consultation?
Thank you, Chair. I also have a few questions in addition to what has already been asked, Chair. The first is in terms of the planned rollout of the court online system at what is called 5 high courts. Whether these have been identified, and if so, which are they, and what were the criteria used to identify the first 5? Then regarding the risks, and as the department puts it, the risk of it being prevented to fully roll out due to external dependencies on CITA and Home Affairs, and then very worrying IJS. The question is really whether the Office of the Chief Justice is, what is the status of their engagement with the role players in respect of IJS? We heard this morning that the latest response from the Ministry and the Department of Justice now is to say the problems with the IJS will be arrested because there's a board in place now, which is, let me not unpack that statement. Let's for a moment assume that putting a board in place will assist this. Is the Office of the Chief Justice then represented on this board? And to what extent, let me ask it this way, how big in their assessment is the risk that these external dependencies would ultimately prevent a rollout at the 5 high courts in this year? Of course, also being mindful, acting chair of the following last year, towards the end of last year, it was prevented that the upgrade of the ICT ICT infrastructure, according to the presentation of the OCJ towards the end of last year, was stalled due to what was called the non-responsiveness of the market. So can we be assured that ultimately, despite those challenges in finding or identifying and awarding a contract to a preferred service provider, that basic upgrade of the ICT infrastructure in fact took place? And then in addition to that, ultimately looking towards Program 2, Superior Court Services, it is envisaged that more or less 1 in 5 of the people employed by the OCJ at this program will be shed come 2024, 2025, with a number of staff being reduced from 2010 to 1,682. So the questions around this is, how will the OCJ go about achieving this? Has there been an exercise undertaken to identify who will be those persons whose functions will be replaced by the online system? And if so, what is the current employment status of these people and their eligibility to be still employed by 2024, 2025? Because ultimately, this is a very worrying thing in the sense that if it is somebody who's in a full-time permanent employment of the OCJ, then of course to just make these posts redundant will have a massive financial impact. And we ask this mindful of the fact that of course budgetary allowance for salaries remain a constant issue, as has been identified again today by the CFO. Then Acting Chair, in terms of the case backlog plan, we were assured on numerous occasions during the course of last year that whilst the Deputy Minister was involved with coming up with a proper plan to address the case backlogs that was first, let's say, accelerated or compounded the issue by COVID and then by the court recording technology. But we were also informed that the OCJ would play a leading role and the judiciary. So if we can be informed as to what has transpired to come up with that final case backlog plan. Then in terms of cybersecurity, we previously the OCJ indicated that they would be dealing with firstly a learning exercise and investigation as to what caused the previous breaches. We see today that it is still identified as a ongoing and present risk. And I don't necessarily want, as we said previously, the let's say all of the final and full details around what is being done, but to say this, Acting Chair, it is a bit worrying if it is presented as a future exercise, that network vulnerability and audits and programs is to be established. But if one considers that the previous breaches happened as far back as 2020, and now we're in 2022, and from the presentation today, it would then seem that the risk remain as it previously was. So I would want to ask, without going into full details, as to whether at least some basic due diligence has unfolded since 2020 and the previous breaches to update cybersecurity and give a better protection. And then lastly, in terms of slide 27, also in terms of risks, there is one statement which I failed to properly understand just on the face of it, Acting Chair, and that is the statement that the in the ranks of the OCJ, there's not the necessary skill set in order to operate in what is called the new normal. And I assume it refers to COVID-19. But it is an astounding statement to make if we for a moment then assume that the COVID is here to stay, as many experts would say. I want to ask the OCJ, what have they then done since 2020 to bring that skill set into play? And if they have not done much, what is the plan going forward? Because ultimately we can't have this situation. And I think that's ultimately the practical aspect around this acting chair, where public institutions just close for days on end for deep cleaning and this and that. I mean, surely we must now be past that. And this statement really worries me that in terms of the OCJ, we're still there. So if that can be unpacked a bit further, thank you.
Thank you, Honorable Werner Horn. The last, Honorable Steve Swart.
Thank you, Chair, and thank you for the presentation. I've been largely covered by my colleagues. I wanted to just touch on one or two other aspects relating to the SCA. And again, with the background of Honorable Breitenbach asked, what role does the OCJ play with this? Because many of these issues relate to public works, such as the issues relating to, in addition to what Honorable Breitenbach said, apparently there's a useless backup generator that doesn't help, that ties up with the issue relating to load shedding. And there was apparently a letter written to the OCJ by the SCA requesting that the SCA should be treated as a national key point. Is there any progress in this? Because clearly it's untenable that the Supreme Court of Appeal should be subject to load shedding and should have a backup generator that apparently does not work. Then can I also just refer that apparently there are problems with basics such as telephones. And can we just find out, because apparently the OCJ has not been able to assist in this regard. This is the feedback that we've had from the president of the SCA. Then I wanted to ask a more broader question about the budgeting process for the judiciary. We appreciate the fact that the OCJ plays a strong role in that regard, but I think it's a concern, and I'd like some clarity as to what role does the judiciary play in the broader budgeting process. Does the judiciary have any direct access to Treasury? I think when we were all in the Constitutional Court a few years ago, when the annual report was delivered by the Chief Justice, where he indicated that there was no input from the Chief Justice besides through the Office of the Chief Justice relating to the budgeting process with Treasury. And we already picked up now recently with our visit to the SCA, where President Meyer indicated a lack of consultation with the judiciary on spending on equipment to be used by judicial officers, which they indicated was the purchase of expensive laptops, for example, that sometimes were not needed. So I'd like some clarity as to that process, which we as Parliament have a similar concern where we, in the budgeting process just for Parliament, so where we sit as three separate legs in terms of the Constitution, that process, I'd like some clarity in that regard. Then there's been concerns about court orders in the past. I'd like some clarity as to what systems are in place to safeguard the integrity of court processes and court orders. I think that is an aspect that must be of great concern to all of us if there are issues related to leaking of or fraudulent court orders, what is being done to enhance those processes. Clearly, from our perspective, we would be concerned about the budget cuts and the impact that will have on the Office of the Chief Justice. As indicated, these will have an impact on the operation of the superior courts in the country, the high courts, the SCA, the Constitutional Court, particularly when it comes to vacancies. And it might be helpful if you were to highlight the very urgent issues. We appreciate the very urgent issues when it comes to that, and so that we have a full appreciation what the impact would be. Increasing backlogs at all the superior courts, local seat circuit courts, training programs would have to be scaled down. Some of these implications, so that at a later stage, we would have been alerted, because at the end of the day, Parliament is the one that approves the appropriation bill, the budget. Just on the court online system and case lines has been very effective. I want to commend OCJ and the Chief Justice for the process of case lines, but it needs to be rolled out broader to all superior courts. And I understand that was going to take place in this financial year. Could we get, is that still on course? My experience with case lines in, I think it's North and South Gauteng courts, it's very effective, and that would be very helpful. And we would like a time frame for the rolling out of these systems to, that's court online system and case lines to the superior courts. Can I just then, I think, Chair, I've basically been covered in these aspects. I think the issue related to the financial constraints was, of course, the main concern. So thank you from my side.
Thank you, Honorable Swart, for those contributions. SG and your team, I now hand over to you to respond.
Thank you, Chairperson and honorable members. We will take the responses, and we'll, with your permission, Chairperson, put together the questions that are related, so that we can deal with that in a holistic manner. I just want to first maybe take out of the way the issues that falls within the area of the judiciary, which is mainly the case backlog, and maybe let's start with the judiciary-led court administration. And I think members are aware that this is a question that we always get. And I think in the minister's overview, he has indicated that he will be giving attention to that. From our side as the administration, quite frankly, this is a policy matter that requires the executive to engage with the views and the positions adopted by the judiciary in their institutional models report that was submitted to the executive some years ago, as already indicated. And therefore, from our side, we will play only a role of an input with regard to the policy as and when the minister begins to engage with that process. And I think that the minister also will be engaged with cabinet on that. So the response in a nutshell is that as the OCJ administration, we will be guided by the ministry and executive with regard to what their response and what the position is with regards to the judiciary-led court administration, and therefore we cannot on our own initiate any progress in that regard. On case backlogs plan, we are aware of what was said in the past regarding the case backlog and the measures that were put in place. But as you will recall, committee members, this matter falls squarely within the role of the Chief Justice and the heads of court in the judicial space, which they deal with when they present their report every year, the judiciary annual report, and they deal with this matter in that sense. I am not aware that at any stage the OCJ, being the administration, will be leading, but I think it is the judiciary that leads on this part, just for the sake of clarity on that one. I wanted to deal also with the issue in general. The CFO will deal with the budgeting aspects. But just to indicate that how the court online will impact the staff in the courts, and how the permanent jobs will be. I think it's one of the questions that was raised by one of the members. The risk of permanent jobs being rendered redundant because of the automation, or especially the code online, etc. Just to say that, members, we have always operated in the administration with constraints with regards to the number of staff that are required to effectively serve the courts. In all the courts, starting with the biggest, which is Gauteng, through to the smallest. Of course, the challenges will differ from court to court, but the limitations remains the same. But we have never had an instance where we had sufficient number of officials to do the work relating especially to the core, which is the court processes. So therefore, we have always operated on a deficit when it comes to skills as well as the competencies and the human bodies to do the work. So against that background, therefore, when automation comes, the natural process will be that obviously those areas that we haven't been able to do, if it frees up the hands of the employees who are there, will be looked at as in that context. But it does not necessarily mean that any job is going to be rendered. I do not foresee that eventuality ever happening in the courts myself, and I can speak on authority on that. But also the other aspect is that there is a natural attrition. Natural attrition being those people who have been in the system for a long time are now retiring in the courts. Those are mostly in the area of the core business of the courts in court processes. So the replacement thereof also becomes an issue with regards to the budget cuts that the CFO has already alluded to. And obviously, as you are listening to me, probably you're asking what is the response? What is the department doing about it? Myself and the CFO, we engage with the HR on this matter to constantly look at how the COE budget impact is on the staff and the staffing of and the human capacity of the organization. And in doing so, we make sure that as attrition happens, as we lose some of the people who have been long and skilled in the institutional court processes, how we prioritize that we do on a regular basis. So I can assure you that it is something that we are really doing on a continuous basis. And therefore, there is no risk of permanent jobs getting redundant. People will just be reskilled into other areas and be able to do that which we do on a continuous basis. I just want to address on the SCA, not necessarily in all the details, with regards to the issues that are raised by the committee relating to the president of the SCA. I must say for myself and the team, we are not aware of any instances where we went and procured any expensive computers or laptops or any gadgets for the judges without any consultation or spending money that is not necessarily supposed to be spent on those items. When COVID hits the courts, as it hit the country and any other place of the world, the computers and the gadgets that we had as ICT tools were not geared up, were not ready for having to do work virtually. And therefore, it means if the computer that a specific judge would have is not compatible to be able to go virtual, naturally we have to go and procure the laptops and the computers that will be able to assist the courts to function virtually, as it was the case in the last 2 years. So that was what was happening. And this I am not aware, and I can stand on that there is no official who will go and buy any computer for any judge and just knock on the door and arrive and present it without having explained. We do that because we do have a committee of judges that also looks at ICT. There's a lot of governance that is in place in relation to how we consult with judges on these matters. And all the courts are involved and all the courts are engaged. I am not trying to say that we are a perfect staff who will do everything right. Of course, if mistakes are made, they can be made, but I can vouch that we've never bought anybody a computer that it does not need. But also on the issue of reinvestment, there was an issue raised around the judges having to buy for themselves the data because we are not able to. There was an instance recently that CETA was off. And when CETA is off, we switch to Vodacom. That is the backup that we have. And we also have Mimecast as a backup when our system reaches some of these glitches that some of them we don't have control over. The OCJ is not in control of CETA, and therefore when CETA is affected, it's not only, I think, the OCJ that's affected, the entire government that is linked there is affected. So, and I can understand the frustration from the judges when they don't understand that it is not necessarily us who are cutting them off. But as I've said, we go to Vodacom and then we go to Mimecast to make sure that we have the backup for the judges, for the courts and the judges and the staff to be able to operate. I just wanted to raise those issues at a high level and just indicate that we are not necessarily oblivious to that. When the judges work at home, as COVID hit, historically, the reinvestment process kicked in, and to make sure that judges, they function, they are paid for the data that they incur. It is not only judges, even officials that are linked to support the judges, we do that for them. So it is policy, it is in place, that's what we have done. I just wanted to get that one out of the way. Maybe let me pause here, Honorable Chairperson and members, and let the CFO deal with the financial aspects, if there's anything he needs to add, as well as Mr. Nubia will deal with the court online aspects. Thank you.
Thank you, SG. Honorable Chairperson, I'm going to deal with the infrastructure challenges that were raised, some of the questions. And then on the budget.
Start first with the budget, Kasi, then we'll come back.
No, your network is very unstable. We cannot hear you. Please reposition yourself.
Can you hear me now, Chairperson?
Chairperson, can you hear?
It seems.
Hello, Chairperson. We can hear us. Oh my God.
We can hear, quite possibly it's the acting chair that's having a challenge.
Oh.
Okay. Should we then proceed or wait for the acting chair?
Acting Chairperson, can you hear us? I don't know if other members of the committee can hear us.
We can hear you very well, but it would be pointless to continue without the chair or the acting chair. So let's just give them
Good day, members. Let me just check with the chair quickly. We'll come back. I think he has network problems.
Hello.
I don't see. Chairperson, can you hear us?
It was me who had a challenge.
Can you hear us, Chairperson? Okay. Can we proceed, Chairperson?
Yes, I can hear you.
Okay, thank you. And I had just paused when I said the CFO will deal with the finances. I think.
Yes, I can hear.
Yes. Just one comment before the CFO deals with finance and some of the infrastructure issues. Just to remind the committee that we still have the facilities management and facility and security management functions retained by the DOJ. So our engagement is obviously via the DOJ to DPW. And that is not an excuse, but at official level, when we do engage with the officials in DPW as and when the matters arise, and I will leave it at that. Just I wanted to just to remind the committee that we don't have that control of that function, though we are not trying to shy away from responsibility. CFO, sir, over to you.
Thank you, SG and Honourable Chairperson. On the issues raised on the budget, firstly, in terms of because the OCJ is a national department, we are guided and bound by the PFMA in terms of the budget processes and principles. Over and above the PFMA, Section 54 of the Superior Courts Act also prescribes the process of the engagement by the judiciary with the Minister of Justice at the time of budget submission. So in practice, the heads of court are engaged in terms of their budget needs and submissions by the provincial heads, which is then combined in a consolidated budget to the OCJ National Office, which is then submitted to the Minister of to the Budget Committee in National Treasury and the Minister of Justice. So to answer the question, because we are functioning as a national department, there is no direct interaction between the judiciary and National Treasury when the judiciary as an arm of state's needs are or should be addressed. And that is basically the only way that the budget is being dealt with, through engagement with the heads of court. Their needs and priorities are submitted, but then it is treated similar to any submission by any national department in the budgetary process. Then on the issue of infrastructure challenges, the SG has already now raised the issue of the retention of the function in the Department of Justice, which then forces the OCJ to directly engage with the Department of Justice and escalate our matters to DPW through that process. However, but that is in the judicial space, and I don't want to go too much into that part. There is an infrastructure committee that was established by the heads of court, which is led by one of the heads of court, and there are engagements with public works at that level, where issues that are then raised with the Department of Public Works are noted and then given to us in the OCJ as officials, and we then at provincial level as well as national level engage with the colleagues in Public Works and the Department of Justice to make them aware of the critical infrastructure matters that comes from the judiciary in terms of the courts. The one issue that we do not, however, have control over is if an issue is raised with them, what the responses are going to be, what the budget is going to be that's allocated, because that falls with, outside of the space and the mandate of the OCJ. On the specific challenges at the Supreme Court of Appeal, I do know that the issues that were raised in terms of generator, roof leaks, air conditioning is on the list that is being dealt with by the colleagues in the province, as well as has been escalated to the national level of Public Works as well. So the OCJ is aware of that, and in those engagements, these matters are attended to. Maybe just to add on to the issue of the computer equipment that the SG raised, I think it's also important that the committee members must note that departments do not procure ICT equipment in isolation. There is a transversal contract or transversal contracts that are issued by CITA for each and every type of equipment, whether it's a desktop or a laptop, with certain specifications that we need to use those contracts with those specifications when we procure. The only thing that we do is we assess whether the computers that are the specifications that are given to us by the transversal companies and CITA, whether they would comply with the needs. And as SG rightfully indicated, for instance, will that type of equipment enable virtual courts? Would that type of equipment be sufficient to implement and maintain the rollout of the requirements of case lines and court online, which obviously needs a higher specification type of laptop or desktop than your normal run-of-the-mill laptop that you can buy from any major store. So there are also prescripts that we need to comply with when it comes to that procurement. SG, I don't know whether you want me to proceed with the CRT issue while I'm on the floor.
Yes. I think on the issue of the cybersecurity, whilst we are still on ICT, there was an issue of cybersecurity, and the member asked for details, not necessarily details with regards to the risk, and why we are still having it in our risk register. I think my comment will be that it does not necessarily mean that we have done nothing since the breach in 2020. We have taken the committee in confidence and submitted a comprehensive report subject to our last meeting when it was raised on what we have done. We are not saying that the issue is not managed. What we are saying here is that we still have to keep our eye on it, because I think even beyond ourselves as the OCJ, big companies are being attacked. They are being breached, banks and every big organization that has more resources than what we have. So it is a risk that we cannot escalate and remove from our side. So I just wanted to clarify that with regards to this still remaining a risk of vulnerability in that context. You can deal with the code recording, but I wanted to deal with because we have covered the infrastructure. The issue of generators is a national problem with the courts, and I don't think it's only courts. All the state buildings are having the same issue, but it is the mandate that falls squarely in the DPW. We do engage with them, but the national key point declaration is a legislation that is administered by the South African Police Service. And to the extent to which they will agree to have the national key point declared on the SCA, one will still have to see whether it will happen, because we have other aspects that we had raised. And there are many engagement that happened in the past, where even the Concord itself and the SCA and others will identify why they are not a national key point. But I just want to clarify that the declaration is a South African Police Service competency, which does not fall within us, and it has been raised before, even at a high level between the Chief Justice meeting with the Minister of Police in the past. I just wanted to place that, and so you can proceed with the other aspect that you wanted to raise.
Thank you, SG. The one question on ICT that I haven't addressed yet was the previous reports of non-responsive bids for the infrastructure upgrades or infrastructure refresh. I can report that those procurement processes were concluded last year in the previous financial year, and the OCJ is awaiting delivery from the appointed service provider. And the reason why there's a slight delay in the delivery is because of the worldwide backlog in terms of manufacturing, and specifically in relation to the microchip shortage that is an essential piece of equipment that comes with every ICT infrastructure that one procures nowadays. So yes, procurement has been concluded. Once the equipment starts arriving, we will then engage or commence with the process of implementing the new infrastructure. On the issue of CRT machines and the court recording technology, I think the committee members have been appraised by the Minister and the Department of Justice in terms of the procurement processes, which have not yet been concluded, of which the OCJ is a partner in terms of a participant of the services. So the procurement process lies within the Department of Justice. We did have an opportunity to make one input to the procurement process, and that was to ensure that the list of all our courts are captured within that procurement process, so they don't leave out one of our sites. So that was our input into that procurement process. But what we have done as the OCJ in the meantime, the SG has allowed us to enter into a short-term contract through a procurement process internally in the OCJ, where we have requested submissions from various service providers to do maintenance and repairs of the CRT machines for a period of 6 months in anticipation that the CRT contract would be concluded by the Department of Justice. And this short-term contract is now exclusively for interim repairs and maintenance of CRT machines in the superior courts to ensure continuation of services. What the Court Administration Unit has also done is when the contract came to an end previously last year, 2021, they realized that there might be a problem and a shortage. The OCJ then also procured a few mobile CRT machines that are then couriered to wherever there is a major problem in this regard, to ensure that where there is a court that doesn't have a machine that's operational and functioning, that we have a backup. Obviously, we do not have enough of those resources, but that is also a measure that has been deployed by the Court Administration Unit. So hopefully, once the contract with Justice is concluded, then we will revert to the contract with the Department of Justice, and then we will also have to make use of their service provider for future repairs and maintenance and procurement. On the issue of the telephones that were raised by, I think, Honourable Swart, telephones in the SCA, the issue with the telephones are linked with the issue that the SG raised on the CITA times. Because we are utilising unified communication systems, the moment the CITA lines go down, then your telecommunication lines also are being affected, because the unified communication system which runs the PABX of the court is on the Vodacom network. So the moment CITA goes down, where we run other services on, everything moves over to Vodacom, and then the Vodacom network gets overloaded, and that has an impact on the telephone system for that short period. So it will be an intermittent issue until CITA has then recovered the lines, and we can then revert back to Vodacom for telephones and internet, and then the CITA lines then take up the other responsibilities of your transversal systems like BAS and PERSOL. So it's an overloading issue. It's not an issue that is persistent or something that needs a replacement of any systems. Thank you, SG. I'm done with.
Okay. Yes, honourable members, I do confirm that I am a member of the IJS board, as well as our representation at the IJS, and further confirm that our online project is funded through the IJS. So I will hand over to Mr. Ncube to deal with the questions relating to the court online, and he can also touch on our role at the IJS level, besides the implementation and the plans going forward. Mr. Ncube.
Thank you, SG, and good morning to the members and the chair. The SG has already indicated that she is a member of the board of the DG Board of Directors for the IJS. There's also the implementation committee, which supports the board, and OCJ is represented in that particular committee. With specific reference to the court online project, there is also a steering committee chaired by the OCJ. There are representatives from different stakeholders, one being IJS, as people who are funding the project. We have monthly meetings that they have been attending since the inception of the project. Also, we have CETA represented in that particular committee, and they attend the meetings quite frequently. So all the challenges that we have been facing in the court online project in terms of the delays all of us have been affected by it, but all of us as a team and a committee, we have been dealing with them. So at this point in time, I must indicate that a lot of progress has been made, and we should be thanking IJS for always ensuring that the funds are available. And they have also indicated to us that we've been able to spend all funds that have been allocated to the project on time, and nothing was ever returned. I think it is also important just to touch on this, Chairperson, because the question was raised regarding the equipment. When we are implementing the court online, one of the requirements was to ensure that there is necessary infrastructure in place. This also includes the equipment that is being bought. So when we decided on purchasing the laptops, just to add on what has been said already, part of the requirement was to ensure that the laptops that are being purchased going forward will be able to support the court online project. So everyone is being prepared for that. So all the courts, especially the SCA and the Concord, we've made sure that the infrastructure is ready for the court online, but also the equipment that the judges are using will also be aligned to that. If it's a desktop for the registrars, it should be all-in-one desktop. So I just thought I should mention that it is not just the thumb sucking, it is based on the requirements as per advised by the SITA and also by the implementing service provider. When it comes to the which courts are going to be next, the role that the OCJ plays is that of advising the committee that handles these issues, which is chaired by one of the heads of court. We've indicated to them, as I've said now, that the court that should be next after Gauteng should be court that will have all the infrastructure ready in terms of equipment, in terms of people being trained and so on. But of course, we appreciate and we are allowed to the fact that the most apex court and the most next inline court, which is the SCA, will have to be considered first. But of course, all other courts, in our view, are just as important. However, OCJ does not make the decision. We only present the state of readiness to the committee, and they then get their direction from the heads of court meeting, which will then indicate which court should be next. But as we've indicated, we've tried to ensure that all the courts are ready, and if required, those details can be made available. But also the committee that I've referred to, which is the steering committee, has also dealt with the issues that SG touched on. What happens when the court online is implemented in all courts? Will be there posts that become redundant? I must just indicate that right now, where we've implemented the court online, as you might be aware, in Gauteng already, with effect from 29 March, we are using some of the officials, the ushers, we've trained them. We are using them as people who are going to assist litigants who will be doing the walk-ins at the court, so that they are assisting them to use the kiosk. But two, we already have call centers in Johannesburg and Pretoria, and the people who are handling that are people who we have identified as the ushers because they're the most experienced and understand the court processes. So just to add on what ST has said, to say this has been looked at. We have HR in our committees who are also ensuring that issues of change management and organizational OD is being dealt with properly. I think SGI have dealt with all the issues relating to court online.
Court integrity.
I'm sorry, SG?
There was a question on court orders, court integrity of the court orders and what's in place to protect it from fraudulent practices.
Thank you, SG, for that. The issue of fraudulent court orders, I must indicate that there is a committee also that is chaired by a judge president at that. And we have been working with the judge to identify the measures that we can put in place to ensure that this phenomenon is prevented. But I think I must highlight that we have two scenarios. The first scenario is where the actual order itself is what's the word that I'm looking for? Is manufactured, for the lack of a better word, outside the court environment. So where a person in the street will create something that looks like a court order. What we have then done is to say, when members of the public, and we can go on our website, when members of the public encounter such and want to verify whether that is a genuine court order, they must approach a chief registrar. And the chief registrar, of course, we don't tell members of the public what we look for, but the chief registrar would then be able to identify certain features that we have put in place to make sure that there's such. If you go back to prior this implementation, you'll see that all the high divisions of the High Court had different templates for their court orders. What happens now that if you go to any High Court, you will see that all the court orders are the same. Just from the face of it, they look the same. And of course, without mentioning in public what the features are, we have certain features that we have put there that only we know how to identify. So that's the first one that we are dealing with. But internally as well, we also have put measures in place to ensure that there is a process from the time, because what we found in very few incidents, what we find is that sometimes these people would approach one of our officials and what would have been a genuine court order, but the contents have been interfered with. So we have put a system in place to ensure that when the judge makes an order, from there on, there is a way of dealing with the information until such time that the judge signs the order. So that we've put in place as well. I don't know if it should be advisable to say it here, but we are happy to divulge what process there is. But of course, the last one would be that in Gauteng, where we have now started with the court online, it will help us a great deal dealing with these issues of fraudulent court orders. Maybe lastly, there was an issue, I know it's not my area, but there was an issue relating to the SC, how often do we meet with DPW? That has been dealt. I just thought I should mention that at the court level, also the directors meet with DPW, not just at national level. At the court level, just for the SCA, because the question was asked specifically, the last meeting that took place between the officials and the director of the SCA and DPW in that region was on the 22nd of March, 2022. So that is quite recent. And these meetings, obviously, they happen quite frequently. And all these issues that are being raised, either by judges or ourselves, are also raised with them. So we have the records to show that these meetings do take place. Thank you, SG and Chairperson.
Thanks, Nati. And to add to what Mr. Ngube has already indicated, the JPs also preside over the PECs, which also include the DPW in the meetings on dealing with some of the issues and the challenges that impacts court performance at court level. I will also touch on, before Mr. Malau deals with the issue of engagements with women department relating to other aspects. There was a question on slide 27 around the tools of, to unpack. What do we mean that the OCJ doesn't have adequate skill sets to operate in the new normal? What we are actually saying in this instance is that on one hand, the budget cuts that are being imposed across all the departments in government has an impact on also our capability to be able to source these tools of trade that we need. That only doesn't include only refer to the computers, laptops, etc. It includes also systems that facilitates work that are related to certain technical areas that you need to buy the software to do certain things. And I think the members would know that currently the leave is automated, is being automated in other areas of government. Pay slips are being automated. There are many areas that are being automated. There are other tools that technical areas need to be able to do their work instead of doing it manually, doing it using the systems. I think that can apply in risk, that can apply in audit, etc. There's different softwares that are required. Those are tools of trade that assist the department or organizations to perform optimally. That is on the tools of trade side of issues. On the other side of this is automation at the court process level, especially, not that it doesn't apply to other administrative side of things. The court online has one aspect that will require ICT automation ICT skills, COVID-19 going virtual, as well as generally, as I've indicated, I think we are now operating in, I don't know whether it's still the 4th or the 5th industrial revolution. I don't want to expose myself, that's not my technical area. The Internet of Things, I mean, everything now is going very automated to the automation side of things. So what we are saying here is that we cannot be oblivious to the fact that the world is moving there to the Internet of Things. And obviously, historically, our workforce was not geared for that. So it is a matter that we need to lift out as a risk to say that once we are trying our best to do all these things, the budget cuts are impacting on us and making it more and more difficult for us to have the resources to be able to be relevant in the world of technology as it stands today. That is in a nutshell my to that question. Thank you so much. Itu, you can cover the area and then we can go back to the chair so that we can take it forward.
Yeah. Thank you, SG. Honorable Chair, there was a question from Honorable Nebo Draven relating to the purpose of the consultation with the Department of Women and the outcome thereof. Chairperson, in relation to the revised framework for strategic planning and annual performance, it requires that when developing our plans, departments should consult with the Department of Women, which is a leading department, on priorities relating to women, youth, and people with disabilities. The main purpose, basically, of this consultation is to ensure that priorities relating to women, youth, and people with disabilities are taken into consideration and forms part of the departmental plans. The outcome of this consultation, Chairperson, led to the inclusion of the 3 outputs that I've already alluded to. The first one being the one on youth empowerment, and the second one being on representation of women at SMS, as well as the one on representation of people with disabilities. So all these outputs have been covered on our APP, and this came as a result of the revised framework as well as our consultation with the Department of Women. Thank you.
Thank you, Chairperson. I think we have covered from our side all the questions that were asked. Back to you, Chairperson.
Okay, thank you. Maybe just from my side, before we wrap up, one just to on a very quick and easy question to connect with Honorable Horn on the register, on the risk register. A simple question to ask SG: is your risk register functional? Is it functional? Or are you having this well put together risk register because it's a work of consultants, there's something in the shelves to impress us about? And I'm asking if it is functional in the sense that, is it working? That's a question that one is asking. And to answer that, one would need to understand whether that unit that's responsible for the functioning of this, monitoring of this, acting on it, is itself fully capacitated What unit is that? Who does what, and is this budgeted for? But it's one thing to, I've seen many who do that. They'll come and present a risk register, and just from the paper, it looks very good, because all you have to do, you have to identify what this risk is or outcome, and is how you're going to mitigate it. But we've kind of grown beyond that to want to know if it's working. And I want you to answer that to the best of your ability, because you're going to be with us. We're going to monitor this. We're going to check it when you come in front of us about whether it is functional. That's a first quick follow-up I want to raise. The second one, SG, I seem to have missed it in your annual performance plan. You can point me towards where it is. We visited the Mthatha Court, High Court. One of the few things that we're impressed about was their library, this judicial library, in support of the judges. There are quite a number of questions that came out of that, and I'm going to use Mthatha so that it covers all the other courts. I have not seen in your indicators, in your issues of objectives, as to how you support these judicial library that are there, and how capacitated are they? And for Mthatha, I'll give an example. You have a good librarian there who has no assistant librarian, that when she's ill, as it happened, for 2 days away, the judges are stuck. They can't get assistant. You don't have an assistant librarian. You don't have a principal librarian. And it's quite an important service. And I missed it. I couldn't pick it up in your indicators, and link that with your judicial education. One of the things they've raised was the lack of training, lack of continuous training of these librarians. Not even workshops that they go to refresh themselves and capacitate themselves more. And then there was the issue of what you call these heritage books. That is basically no budget for it. Your law reform books, and I mean, you could see it there in that library. You've got a lot of material there, which is important for the work that the judges do, and they don't seem to be getting this kind of a proper assistance. You know, these heritage books that you have, that you can't even cover them because they have got to remain as they are, as part of this jurisprudence and a home kind of grown thing. So I'm just interested as to, are you able to point to me how that support from your APP is done, so that we can follow that? And the last point had to do with this disposal of old kind of items that you've got in their space. They're not able to have a new space because there is no service that does this to empty what they no longer kind of need. And yet in some high court, it does happen. Thank you, SG, your response.
Thank you, Honorable Chairperson, members. I will deal with the risk. Firstly, to assure the committee that we do have a risk unit at senior management level, which is responsible for risk, and whether our risk is functional. The risk features at 3 levels of our governance. We deal with this aspect at operational level, we deal with it at EXCO level, we deal with it at under the oversight of the Audit and Risk Committee. So the Audit and Risk Committee is very rigorous with us when it comes to this risk for the institution. So that is where we are really taken for task. And I can assure you, we don't have consultants doing risk. Like every other aspect of our work, we do homegrown internally. So we don't cut and paste from any Google or any documents and say this is our risk. I can assure you that, Chair, we really get engaged with the risks. And every unit with the risk manager sits and really go through a proper workshop engagement on the risks that are affecting or other emanating from each area. And even in the course, we have risk champions, which the risk manager nationally here work with to make sure that risk is internalized and institutionalized as part of our business. So the answer is yes, it's functional, yes, it's monitored, even at audit and risk level, as well as the role that the risk manager play in that role. So that is how far I can assure you, Chairperson, that it's fully capacitated and all that. Except to say that our risk manager resigned, so we are filling the post. I think the post will be filled very soon. There's already been advertised. As soon as the manager left the end of January, we advertised that our one is coming. So there's nothing that is falling into the cracks. And the work is being done. And I can assure you, for instance, we have 100% e-disclosure of the SMS is at the end of April, to just as an example to show that our risk function is really functional. The issue of the the library, and that you have not seen it in our indicators. Some of the issues I will leave to the head of court administration. I think the DDG and the chief director, they will deal with these aspects of the librarians and their support and why they don't appear in the APP. We also have an operational plan which deals with some of the aspects that might not necessarily appear on the APP, as well as other areas that the director's court operation will be held accountable for. And I will leave that to and ask the court administration to deal with that. Mr. Ncube will deal with that with Advocate Potgieter on that, as well as dealing with the disposal of old court documents, which is obviously a very problematic issue for all the courts because the National Archives are full. Putting documents online requires huge amounts of money, which we don't have. On the other side, budgets are being cut. It's really being between a hard rock and a hard place. But we do try to make sure that we find ways within our meager budget to find ways that we can be able to manage that. But that, I must concede, is a problem with regard to court documents because of the bulk of the documents that we have. And we think that maybe beyond and after the court online, this problem will begin to recede, although the historical legacy of the documents will still have to be attended to. I know that the Justice Department has had that project. Court administration will talk more on that and deal with that. On the support to the librarians, yeah, I think I've already mentioned that. The court administration, Nati and Marlies can deal with that.
Thanks, SG. On the library issue, the SG has already indicated that we actually have that as one of our KPIs on our operational plan. But I think it's important as well to mention that we have committees that we have set up for librarians, which is chaired by one of the directors here. So whatever information in terms of support that librarians need, they can get it from the director who's responsible at national level, but also that forum was created so that there can be a sharing of information with particular reference to assist them to access the Constitutional Court Library, which is one of the biggest. So they have that particular support directly. and as I've said, through the committee and through the chairperson. But the issue of course, purchasing of books is still an issue that is with the Department of Justice. We are able to buy some books, but in the main, the Department of Justice is responsible for that, and they have contracts in place to do that. In view of where we are in terms of technology, a decision was then taken to say, instead of buying all the books that would need physical updating, most of it is then done online, and that resource is always available, even as far as Umtata. Now, of course, there is an element of human resource. Chairperson, you would know that we are struggling with the issues of capacity, almost all departments. We have a librarian, and he's quite a good librarian at Umtata. It might be that he believes that he needs maybe an assistant. However, at this point in time, when we prioritize, we'll prioritize a librarian, and we will then make arrangements within to have somebody who would then be an assistant as and when required. It happens in most of the positions with us. Unfortunately, we can only have one court manager. If the court manager is not there, we definitely have to find somebody who must act or assist. We only have one chief registrar. If she's not or is not there, we have to find somebody that must assist. And that goes with every other position, including that of a librarian. So that's the approach, but they always have support that is available to them as and when it is required. Now, when it comes to the issue of disposal of assets in general, but whether it's books or some of the old court files, we are dealing with two issues. The first one is that we do have disposable committees as it is required in terms of the prescripts at every provincial level. That committee will then sit and identify what needs to be disposed of and then follow the prescribed process and report to national office. That's one part. So when there are issues of old books that have been identified and must be disposed of, then they get disposed. I particularly was present, at least before the COVID hit in Eastern Cape, when they were dealing with that particular issue, and we dealt with it to what was expected, at least in my view. So that's the first part. But the issue of space is as a result of the court files where we are running out of space. And that is because the High Court, Superior Court files cannot be, unfortunately, be destroyed. And this is why we've then at OCJ have come up with one, as SG has said, the court online will assist going forward, but it can't deal with, obviously, the legacy problem. And as a result, we have made a submission to IJS, which has not been approved at this point, to assist us with digitization of old records. Once all the old records, which run into millions, really have been digitized, we should then be able to make space for the old ones. But I can just inform you that it's a concern that we all share at all levels, particularly with the big divisions. It's a serious problem, but it's a problem that we are trying to find solutions for. And the main solution is to have those records digitized so that if we're able to dispose of them, then we can, but we can't dispose when they have not been digitized. I hope I've covered everything, SG.
Yeah, I think you covered. No, something about the training of librarians.
Yes.
I don't know if you touched on that, did you?
Yes, there is such a training. What we have done at OCJ, perhaps, which is not something that is done across the board. Each position, for instance, as I've said, the librarians, we've created a forum where all these librarians are able to meet quarterly, and they also interact throughout. So there's information sharing that happens. but also there's an exposure that the director who chairs this forum has ensured that it happens, which is access to the Constitutional Court, where they are able to access, but also they are able to receive some kind of assistance whenever there is. Remember that they have, I'll call them workshop. I don't know if it's correct to say it's a training, but they have workshops quarterly where issues are being trained and information is being shared. So that's how we deal with it, which is this particular forum. And of course, we are happy to share that information if there is a need. Thank you, sir.
Okay. SG?
Yes, thank you, Chairperson. From our side, I think we tried to cover everything.
That's fine. Just before I wrap up the last point, you don't need to answer it now, but there was the Deputy Judge President of the court, and there is something very interesting that I also don't see in the APP, that of producing these judgments, this law, and then we end up going to buy them back from Jutas and Van Wyk. That you are saying there's a gap. There's supposed to be a project that we do so that we ourselves as creators of this are able to produce this, and it could be what you call self-sustainability kind of a project. So there's nothing like that you do.
The Chairperson, I'm not sure whether I should answer that now or leave it for later. You said I shouldn't.
No, you can
I can exercise that option, but just to say, and Nati can come in, because the judges have raised exactly the same thing at their forum as a head of court. And obviously there are more dynamics involved than simply us having the capacity to take a judgment of every court that is reportable and translating it into what is a reportable case for public consumption and academic use, etc. So there are a lot of dynamics involved. So we are allowed, the judges have really are unhappy about that. The entire judgeship is very unhappy about that. That costs a lot of money to buy from Judicial, Lexis, etc. And those contracts are run through Justice Department, as you would know. But we have internally looked at that matter. Maybe Nati, do you want to give some highlights on the project? It's a project of the judiciary, so maybe at the right time let's share it later on. Yeah, let's leave it at that.
We can give highlights, but that's a project that we're going to be interested in. We can come back to it, but Nati can say whatever he wants to say in a minute. But it's an important project.
Okay, we noticed. Yeah.
Oh, sorry, Esther.
Proceed, Nati.
Oh, yes. I just wanted to say that firstly, if you look at our APP chair, you would see there is something there which is called Monitoring Reports on Law Reporting Project. Yes. So that is what you are talking about. I have to indicate that it's as SG has said, it's something that the former Chief Justice was very particular about, and the heads of court, of course, wanted this particular issue to be addressed. There has been, it's a very long exercise. We were tasked as OCJ to engage with different jurisdictions to see if there are things we can learn from them, but we have started the project. So the only highlight perhaps that if I may be at liberty to share, was that for a starter, we wanted to have a portal where all judgments will be deposited, which will serve as a repository. So that judges are able to access them irrespective of where the judgment was. And from there, we can then embark on making sure that we get to a point where they produce their own law reports, if one wants to call it that. But it's going to require a lot of money. It requires a lot of systems to be put in place. And it's really going to be a phased-in approach. But this is where we are now, and we are working on that. And to see that particular KPI in that report. That's all I can share, SG, at this point, and Chair.
Okay. No, thank you, SG. We will basically travel that journey with you. You know that it's been raised, and so if it was a project that you are doing at your own leisure, we want that project to become real, given its importance and so on. So unless any member wants to raise anything else, I see Honorable Swart, that's your old hand. I think that's a legacy hand. If none, therefore want to thank you, SG, and your team. Your final comment before we wrap up?
No, thank you very much, Chairperson and honorable members, for engaging with us. We've noted the areas of your concern, and to the extent that it is under our control, we'll ensure that we manage those, and those dependencies, of course, will be managed as we try to move forward. And thanks for your support and for your guidance. Thank you so much on behalf of the team.
Thank you, SG and the OCJ team. Thank you very much, honorable members, for your interrogation, as always, being on top of your game on these issues. We had promised Honorable Swart that will be done before you leave. So that's the end of it, Honorable Swart, and I think you've not missed anything. In that way, I want to thank you and then say the meeting at this point is adjourned.
Thank you, Chair.
Recording stopped.